right, everybody, welcome back to the Learning Out Loud podcast. I'm your host, Dustin William. I have my co-host with me, Whitestone.
It is undeniable that a vast proportion of the actual doctrines and rules which make up the system of equity are necessarily inferences from or direct applications of some or more of these fundamental maxims.
The power is neutral. It's sitting in the quintessence until you invoke it. Behind using these things are good and holy and Christ-like.
I shall now attempt to show how the most important of these principia have been crystallized into the pithy form of maxims and have influenced and developed that grand system of truth known as equity jurisprudence.
All right, welcome everybody back to the Learning Out Loud podcast. I am your host, Dustin William, owner and producer of True Life Productions. You can find all of our work at truelifeproduction.com. Such as All Aboard, my history show where I go deep into the history of New York with a special emphasis on the orphan trains. And in addition to that, I'm putting together something else called The Hidden Origins of the Orphan Trains, where I go through Charles Loring Brace's entire history before the trains even started, the really important context of the whole thing. So stay tuned for that. And then from there, you can head to Article 3, Articulations, where I talk about Supreme Court decisions, break them down fully, give you a bunch of extra context so that you can understand them better. Over there, you can find the most comprehensive breakdown of the slaughterhouse cases there is on the internet. And then from there, you can head to the Thought Crime Dojo, where you can watch my research as it happens. I'm adding new stuff to it literally every day. I just started for 28-day study guides covering, first we're covering the trivium, then we're learning Hebrew, then we're learning the equity of redemption as told to us by John Norton Pomeroy. We're going through the redemption stories of the Bible, and then we're heading to the equity of redemption with John Norton Pomeroy. So there's something new every day for you to go check out, something new to learn, some really interesting stuff to get into. But that's enough of the business. Let's get into what we're talking about today. Let's introduce our co-host real quick. Whitestone, how's it going, man?
Oh, I'm doing great. I'm actually I'm sun gazing right now while we're sitting here, and I'm looking forward to talking about equity.
Nice, perfect. Yeah, I think I got a pretty good show lined up for us today. I'm excited to get into this one. Today we're actually going to talk about two maxims. Hour one, we're going to be talking about equity is equity, or equity delighteth in equality, as Story puts it. And then in hour two, we are going to head into where there are equal equities, the first in order of time must prevail. And these are, you wouldn't, they kind of seem self-explanatory to me in the beginning, but as you dig deeper into them, there's a lot of interesting stuff in these two maxims here. As we continue on our journey through Murray F. Tuley's speech to the bar in 1903, we have made it all the way to page 30. So that's where we're going to start today, is page 30, equity maxim number 6, as told to us by Murray F. Tuley. So starting out, equity is equality. The only exception to this statement of the maxim by the text writers is an addition made by Story. He has it, equality is equity, or equity delighteth in equality. Pomeroy says that the notion of equality or impartiality lay at the very foundation of the equities, or conceived by the Roman jurist, that the same idea was from the outset incorporated into the equity jurisprudence created by the English courts of chancery, and it's been perpetuated into all of its doctrines into which the notion could possibly enter. Home, or Lord Kames, in his History of Equity, page 455, says, in speaking of this maxim, that it is not peculiar to the English jurisprudence, for we find this provision in the Code of Hindostan, When several men are creditors at the same to the same debtor, they shall make a sort of common stock of their debts and receive their respective shares of each payment. If any creditor refuses to accede to the agreement, he shall lose his share. Equity, unlike the law courts, regard and protects the rights of all parties connected with the subject matter of the litigation. And this principle that equality is equity, or equity delighteth in equality, is of a very wide range. It is the conceded source of several important and distinctive doctrines of equity jurisprudence. It is applied where equity enforces a pro rata distribution and contribution. The common law sometimes gave preference by reason solely of the form of the security, but equity refused to recognize any such preference because of the form of the security, which that goes back to equity regards the substance over the form, a maxim we've talked about before. Moving on, in case of joint obligations, compelled contribution from the co-debtor to one who has discharged the debt upon the principle that equity is equality. Equity ignored the rule of the common law that where the land is jointly purchased or where there was a joint contract for the purchase of land, the right of survivorship existed in cases where, by reason of the circumstances attending the transaction, it could reasonably be implied that no such right of survivorship was intended. It also compelled contribution from the estate of the joint obligor when, at common law, there was no remedy whatever. Um,
It's interesting that quote from Lord Kames, when he said it's not peculiar to the English jurisprudence, for we find this provision in the Code of Hindustan, which I think Hindustan was the name of India before it became India.
Pretty
But
sure, yeah. Yep.
even India has a tradition of civil law, and that's another rabbit hole about why the civil law, judges wearing the black robes,
Mm.
sitting in houses of pillars adjudicating the law. We actually find that all over the world, even in countries that you wouldn't suspect. But anyway, um, it's interesting that that quote right there, that if several men are going to be creditors to the same debtor, they all get equal shares. Respect, for payment. And if any creditor refuses to accede to the agreement, he shall lose his share.
Hmm.
That's actually pretty much the overarching theme for the Supreme Court case that we're going to cover in hour two.
Yeah, yeah. I thought, yeah, this little section definitely hit on exactly the case that we're going to talk about later, which we could talk for hours on. We were talking before we got on the show. It's good. It's a really interesting case. I'm super excited to get into it. And
Yeah,
go ahead.
no, I was gonna say we basically recorded a whole other show just on talking about this case before we even got.
Yeah, I know. We probably should just do a whole show on the case because if we really dug into it and dug into the history and like what actually happened behind the case, because there's a lot of, I would say, context missing from the case just because in fraud and people scamming people, there's always going to be missing context because they don't want to get caught.
Oh
But
yeah,
yeah, if we really dug into it, because we're pretty sure this is the case where the whole term Ponzi scheme comes from. Because it's about
yes.
a guy named Charles Ponzi who ripped off a bunch of people in a really
Yeah.
ridiculous way. It's
Yeah,
hilarious.
basically creating these shadow securities and creating an entire, like revenuing monetary system is basically what he created. And,
Yeah.
that's the case that took place between 1913 and 1933. And that's, when we get the Federal Reserve and we get, the socioeconomic restructuring in 1933. This case is almost a blueprint for what is about to come.
Yeah, yeah, absolutely. Yeah, let's not go off too much on
No, yeah, you're right.
it
You're right.
because we
Okay.
don't. Yeah, but
So
let's keep digging into the speech real quick.
continuing on,
Yeah.
uh, it underlies the whole doctrine of equity as administered in the settlement of insolvent estates and the marshaling of assets. Equity will not only apportion the assets upon the principle that equality is equity, but will compel firm creditors to resort, in the first place, to firm assets, and individual creditors to resort to individual assets before either party can resort to the balance remaining of any other kind of a fund. Its application is also seen in regard to the payment of legacies, where estates are insufficient to pay all in full, and the apportionment of debts secured by mortgage among various owners of the mortgage premises who have become such after the giving of the mortgage, make a pro rata appropriation among the owners of the parcels of land, and when necessary, among the holders of liens or interests. It is also applied in cases where the donee with a power in trust for appointment among members of a designated class refuses to make such appointment or dies without selecting the beneficiary. The Court of Chancery, on the principle that equality is equity, will carry out the power by dividing the fund or property in equal shares among all individuals in the
Mhm.
designated class. So I think to simplify that, anytime there's anybody that has a claim on an estate, if all of their deposits or all of the interests that they have are a part of a general fund, equity is going to tell all the creditors that we are going to divide everything equally among everybody.
Which goes right back to the case we're going to talk about too,
Yes,
actually.
and that's what
That's
they're
how they
talking about
divide
in
money.
designated classes, because sometimes in one suit you can have different classes of creditors, where there might be one class of creditors that has a preference, or they basically have they get first dibs, they're first in line, and then whatever's left over is equally distributed among the second class of creditors who have claims. And so that's one thing the court looks for is, you know, whose money is whose? Is anything on special deposit? Is anything in a trust? Is it all in a
Mhm.
general fund? And who gets what?
Or is everybody commingled? Is it
Yes,
all
everybody
spaghetti
commingled.
together? Yep.
And that's how they get you out of equity too, is by getting you to commingle
Hmm.
everything, because then you can't have an equitable lien or an interest on it if you didn't restrict the deposit.
Yep.
So
Absolutely.
moving on, one of the early leading cases is Reeves versus Reeves, decided in the reign of Charles II. Richard Reeves, having a daughter by his first wife, charged certain lands in Bickerton with £3,000 portion to his daughter. He subsequently married a second wife to whom he made a jointure of a moiety of the Bickerton lands, taking no notice of the charge of the £3,000. Jointure of a moiety is like the lion's share, the majority. So basically, when he married his second wife, all that land he had promised to his daughter, he now entered into a jointure or some kind of arrangement with somebody else that included all of those lands and completely ignored what he had promised to his daughter. So he made a will referring therein to the £3,000 and devising lands in Yorkshire to his wife in lieu of the Bickerton jointure. The widow refused to accept the device because the settlement by jointure would prevail against the charge of £3,000 on the Bickerton lands. The daughter filed a bill for relief. So basically, what he did is in his will, he's like, "Yeah, about that £3,000. You don't have it in the land that I originally promised you, but you can have it in this other land here."
Hmm.
So she refused to accept the device because the settlement by jointure would prevail against the charge of the £3,000 of which she was originally promised. So she filed a bill for relief. The Lord Keeper, Sir Thomas North, decreed the plaintiff should have such part of the lands in Yorkshire as should be equal in value to such of the lands in Bickerton as were comprised within the jointure until her portion was raised. This case was cited with approval by Lord Hardwicke in 1772, and in the case of Landsey v. the Duke and Duchess of Athol, in which he declared, "It is not then the constant equity of this court that if a creditor has two funds, he shall have his satisfaction out of that fund another creditor has no lien on."
Yes, then if a creditor
Yeah.
has two funds, he shall have his satisfaction out of the fund another creditor has no lien on.
So if you have two funds, or basically two lands that are in question, whichever one doesn't have a lien on it is where he
Oh,
would get the
right,
satisfaction.
right. Yeah,
So
wherever
it's
there's
like,
not a lien.
and
Yeah.
the thing is, I think that, let's see. Yeah, because originally he had promised land. He had charged certain lands in Bickerton with 3,000 pounds portion to his daughter, and then later on promised it to somebody else. And the court
Mhm.
said, "All right, what land does not have a lien on it? This one? Okay, so basically you have an equitable interest in this land until you are satisfied up to and including your 3,000 pounds." So they're like,
Mhm.
you're still going to get your 3,000 pounds out of the land. It's just not going to be the land that was originally promised to you because that one has a lien
No
on it
lien on it.
now.
Yep.
So
Yep.
I think that's kind of what they're pointing on, and they're again, um, equality is equity, equity is
Right.
equality, and they're just
Yeah.
trying to give everybody what it is that they were promised, regardless of where it comes from.
Yeah, because if already somebody else already has an equitable title, a lien on that land, they can't just give that away because that's not they don't have they wouldn't have a complete title to the land.
Right,
So they have
right.
no right to give it away to anybody. So equity's coming in and saying, "Oh, all right. So you got this land, so I guess you got to
Yeah.
give that land."
It's like,
So
okay, sir, do you have anything that doesn't have a lien on it?
right.
Oh, okay. You have some
Yeah.
in Yorkshire? Okay, that's what she's getting. Do you have
That's
anything
what
else?
she's gonna get. Yep.
Yeah.
Yep. Unfortunate for you. That's just how it works, you know?
Sir, you need to stop marrying all these women and
Right.
promising them
And
lands.
promising them land.
Okay.
That must be how he was getting the wives. I got all
Yeah.
this land for you.
I got all this land. It's like, hey, this land is working and making money. You want 3,000 pounds of it? And then, a couple weeks later, he's off marrying some other chick. And she's like, hey, you literally promised me this land. He's like, oh, yeah, you can, hold
Oh,
on, babe.
shucks.
Yeah. Hold on. Yeah, no, it's not a problem. It's not a problem. You can have this other land in Yorkshire. There you go.
Getting in too deep. Getting in too
Yeah.
deep. All right. Moving on. This will just finish up the speech here. There's only a little paragraph to finish up here, and then we're going to jump into some Pomeroy. But continuing on, because there was no case directly in point, Lord Hardwick took Reeves v. Reeves under advisement and kept it under advisement more than a year. And that means he just took the case and had to think about it because there was no precedent set. So he had to do some research. So he took it under
Uh,
advisement. Yeah.
that's a, I'll get back to you in 3 to 5 business years.
Right. Yeah, exactly. And then, I think it was only about a year, but yeah.
Oh,
And then he reversed himself, quoting, with approval, he remarked of St. Joseph Jekyll, which he said no chancellor should be ashamed to constantly have in mind, and which is this: there are no reasons which induce me to alter my opinion, and I am not ashamed of doing it. For I always thought it much greater reproach to a judge to continue in his error than to retract from it. From this, it appears that even in those early days, it was permissible for a conscientious chancellor, when there was no case exactly in point, wishing to make a strenuous effort to do equity, to take a case under a long advisement. So he took the advisement and then he reversed his decision because no there was no precedent on it. So he basically
so
gave
he
the
had to.
decision, took it under advisement, and then reversed his decision.
Wow, interesting.
Yeah, yeah, yeah. I thought that was interesting too. But I do like what he says here. There are the reasons which induce me to alter my opinion, and I am not ashamed of doing it. For I always thought it much greater reproach to a judge to continue in his error than to retract from it. So,
Yeah.
but he's basically saying it's reprehensible for you to not correct your errors.
Yeah, and if you want to just, if you want to save face and just keep making the same error, you're not going to be doing equity.
Right, exactly, exactly. So he's like, yes, this is embarrassing as it is. We all get shit wrong. So,
Yep.
he had to reverse his opinion there. And so that'll finish up Murray F. Tully's speech for equity maxim number 6. Equality is equity. And then from there, um, actually, I wanted to move on to Pomeroy because he's got some good sections on this. And obviously, this is where Mr. Tully drew a lot of his speech from. So we'll just go right to Mr. Pomeroy over here and see what he has to say about the equity maxim, equity is equality. So I'll just read this section 405 into the record here. This is section 405 from Equity Jurisprudence Volume 1. I think this is so it's the fourth edition. I think it's the fourth edition, either the third or fourth edition. And so he basically just goes through the definition of what the equity maxim means. So Section 405, its general meaning. We have seen in the opening paragraphs of the introductory chapter that the notion of equality or impartiality, equum, lay at the very foundation of the equities as conceived of by the Roman jurists. The same idea was, from the outset, incorporated into the equity jurisprudence created by the English courts of chancery, and has been perpetuated in all doctrines into which the notion could possibly be entered, until the present day. While the common law looked at and protected the rights of a person as a separate and distinct individual, equity rather regards and maintains, as far as possible, the rights of all who are connected by any common bond of interest or of obligation. The principle equity is equality, or equality is equity, or equity delighteth in equality, is of very wide and general application. It is the immediate and conceded source of several important and distinctive doctrines of the equity jurisprudence. But this is not all. It furnishes a practical rule for the guidance of equity courts in their administration of reliefs. Whenever they obtain jurisdiction over a great variety of cases, unless some compulsory dogma of the law stands in the way, I shall briefly mention the important equitable doctrines which are derived from the principle and indicate a few cases in which it operates and controls the administration of relief, which we're not going to go through that section. But what did it say here? The right I did one of the biggest reasons why I love Pomeroy is because he points out the distinction between common law and equity all the time. While the common law looked at and protected the rights of the persons as a separate and distinct individual, equity regards and maintains as far as possible the rights of all who are connected by any common bond or interest of the obligation. So basically what he's saying there is at common law one winner takes all. There can only be one winner. You can't divvy up the stuff, and it doesn't matter how many people are involved. You get one winner. The plaintiff basically is there's the plaintiff. It's either the plaintiff or the defendant that is a winner. But equity rather regards and maintains it as far as possible the rights of all who are connected by any common bond and interest of the obligation, which we'll go back to the case we're going to talk about in just a little bit, the Cunningham case. Oh, come on. All right. So that goes over the. Oh, wait, no, we are going to go through section 406.
Yes, I can get into 406.
Yeah.
I mean, it's really not that long.
It's a little bit of a read, but I do think it adds a lot of good context for the case we're going to talk about later.
Yeah, I can go through it real quick.
So yeah, let's do that.
All right, so continuing on from after 405, we're now reading 406. I'm going to actually be reading out of the third edition of Equity Jurisprudence, but there might be a little change here or there in the verbiage, but it
should be pretty close. Yeah, should be pretty close.
So subsection 406 is the source of certain equitable doctrines, pro rata distribution and contribution. Wherever a number of persons had separate claims against the same individual or the same fund, the law generally gave certain classes of such claimants a complete precedence, even to the exhaustion of the fund, if necessary, over the others, arising solely from the form of their security, as, for example, bond and other specialty creditors over simple contract creditors. Also, among several persons having claims of the same grade against a single individual or fund, the one who by his superior activity, either by means of action and judgment or not, obtains payment of his demand the first in order of time, is entitled at law to the precedence thus acquired over the others, even though they should thereby be prevented, in whole or in part, from procuring satisfaction. Conversely, It is a familiar doctrine of the law that when a creditor has a single claim against several persons, each of such debtors is regarded as so completely and individually liable that the creditor may enforce payment of the entire demand from any one of the number. That actually gets into the law of contribution and subrogation. If you read that, where if one debtor decides to pay the debt of co-debtors, he can then turn around and now demand payment from co-debtors for his reimbursement.
Mm, mm-hmm,
But
mm-hmm.
um, let's see.
The law will not interfere.
Yeah, the law will not interfere with, thank you. The law will not interfere with the action of the creditor. It will not compel him in any manner to obtain satisfaction from all of the other debtors pari passu. And after one of the number had thus been obliged to pay the whole amount, the ancient common law, prior to its adoption of doctrines borrowed from equity, failed to give him any right of recourse upon his co-debtors, by means of which the burden might finally be distributed among them all in just proportions. So basically what I just said.
Mhm.
Rules of the modern law giving such right of reimbursement are a direct importation from the equity jurisprudence. Finally, the common law, prior to statutory changes, exhibited a decided preference, in fact, leaned very strongly in favor of joint ownership over ownership in common, and in favor of a joint right among creditors over a several right, and a joint liability among debtors over a several or joint and several liability, with all of the legal consequences of survivorship and of an extinction of the right or liability on the part of any one of the creditors or debtors who dies. Under all these conditions of fact, equity proceeded upon a very different principle, upon the principle that equality is equity, that the right or burden should be equalized among all the persons entitled to participate. It must not be understood, however, that a court of equity would always directly interfere with parties under the circumstances above mentioned for the purpose of carrying out the principle of equality. It could not, for example, restrain a creditor from prosecuting his legal demands by legal means merely on the ground that the result would give him a precedence over others. In other words, the principle of equality is equity was not of itself the source of an equitable jurisdiction which would not otherwise have existed.
Mm.
The true doctrine is that wherever a court of equity, upon any ground of equitable cognizance, acquires jurisdiction over a case falling under the general condition of fact mentioned above, it will apply the principle of equality in determining the collective rights and liabilities of all the parties.
Interesting. Yeah, I know that one was a little bit long, but I think that gives a lot of important context to the case we're going to talk about here in just a little bit.
Yes. And I think basically what it's saying is that if anybody is linked to a fund or linked to an obligation, they're going to distribute the obligations or the benefits or the demands equally amongst everybody that's involved.
And here so and he also talks about is like this maxim isn't going to get you into a court of equity. But once you get into a court of equity, this is going to be one of the most governing principles once you're
Yes.
actually behind those.
And if the facts are such that warrant that kind of jurisprudence, then the court will take cognizance of it and will proceed according to the doctrine of equality is equity.
Yeah, yeah, absolutely. But you just got to get your foot in the door first.
Yes.
So, and then I had, so yeah, I thought, and then yeah, I wanted to hit settlement of insolvent estates, obviously, because that's going to be,
Oh, that's a fun one.
yeah, we're going to be drawing on that one a little bit too. So, moving on from there, we're going to skip a couple of sections there and move on to section 410 in the same book, talking about the same maxim, equality is equity. And this section is labeled Settlement of Insolvent Estates, Marshaling of Assets. So, another remarkable and most just application of the principle, often leading to results very different from those produced by the operation of legal rules, may be seen in all instances where a court of equity acquires jurisdiction from any cause to wind up, distribute, or settle any estate, property, or fund against which there are a number of separate claimants. One example is that of settling the affairs of an insolvent partnership, corporation, or individual debtor in a creditor's suit brought one on behalf of another creditor, where the assets are not sufficient to satisfy all demands in full. The court always proceeds upon the principle that equality is equity and of apportioning the property pro rata among all the creditors. The principle is carried to such an extent in the settlement of insolvent partnerships and partnerships where one of the members has died that firm creditors are compelled in the first instance to resort to the firm assets and creditors of the individual partners to individual assets before either class can have recourse to any balance left remaining of the other kind of fund. Okay, so individuals get taken care of first. That's good. A second example is that of marshaling the assets and the administration of the estate of a deceased person. At the common law, certain classes of creditors enjoyed a precedence over others and were entitled to be paid in full, even to the exclusion, oh, excuse me, of the even to the exclusion of the inferior orders by the administration or executor out of the legal assets of the decedent's estate, according to their established priority of right. But a court of equity, having obtained jurisdiction over an administration, regards all debts in general as standing upon all an equal footing and as entitled to payment pro rata out of the equitable assets. If the estate is not sufficient to pay them all in full without any reference to their legal right or priority. In order to attain this result and to carry out the principle of equality as equity in administrations, the doctrine of marshaling assets was established. Okay. And I wanted to hit on that because it talks about in the Cunningham case, it talks about how everybody died or or left as the litigation was taken off, and he kind of touches on that in here.
Yeah, it's just interesting that the progenitors of the Ponzi scheme, those trustees, just miraculously died and resigned during litigation.
Isn't that weird? Left Cunningham all on his own. All on his
Yeah,
lonesome. Yeah, 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 well, so I guess we can get into it now. 'Cause now that we've covered the what the primary sources of the equitable maxim now. So now we can move on to what the Supreme Court has to say about these equity maxims. And we can finally get to the case that we've been talking about, kind of hinting at here.
I will say real quick before we move on, reading what was that 410 that we just read,
Yeah, 410.
talking about the administration of the administration of estates and marshaling of assets of deceased persons.
Yeah. Yeah,
So
that's
if you are still considered not being of the living, then your estate is being actively administered by, executives and administrators that have been charged with doing that. So, if you really want to understand kind of what system is taking place here, you have to understand how the estates of deceased persons are administered and why you
yeah.
might not want to be considered a dead person.
Yeah, and if you're not aware, you are considered a dead person right now. You are a
Yes.
decedent and you are being administered by
Yes, if you don't come
administrators.
forward and say that, what's that Pearl Jam song? I'm still alive,
Oh yeah. Yeah, yeah, right. You got to play Pearl Jam in front of the courthouse.
Yeah, if you bring Eddie Vedder into a court of equity and just play I'm still alive and don't walk out with a decree, I'd be surprised.
That's hilarious. But yeah, that is a great point to hit on right there is the administration of dead estates because like we just mentioned, that is exactly what's going on right now. So in order for you to understand what's happening with your estate behind the scenes, you have to understand how dead assets are administered or decedents are administered, sorry. Okay, yeah, good, great little point there. So, with that, then we can move on to Cunningham v. Brown here. And did you say you wanted to run through the 5 points here before we get to give our opinion on the case?
Yeah, just to give people an overview of kind of what it is that what it is that they're pointing at here. Okay, so really what this case is, well, actually, you know what? Let's just start.
Yeah.
Okay, Cunningham, trustee of Ponzi v. Brown. Um, let's see, Court of Appeals for Circuit. Number one, where a person obtained money by fraudulent representations from many others upon his time notes for the amounts borrowed and 50%, that means interest, 50% interest,
Hmm.
but to stimulate public confidence, gave it out that he would return the amount borrowed on any note at any time before its maturity and pursued that practice, held that lenders who took advantage of this offer and secured repayment shortly before his bankruptcy, when they had reason to believe him insolvent, were not thereby rescinding their contracts for the fraud and reclaiming their own funds, but were creditors equally with the others who filed their claims for reimbursement in the bankruptcy proceedings, and that the repayments thus made were legal preferences recoverable by the bankrupt's trustees.
There's a
So
lot going on in that first
that's
point.
that's a big mouthful, but
Yeah.
basically what it is there's a guy, Ponzi, the progenitor of the Ponzi scheme, had told a lot of people that he was going to be making investments in foreign money stamps or foreign postage stamps, and got a lot of these creditors and investors to give him a lot of money in order to do that. And what he was doing was they were giving him money, and as he basically issued them a promissory note, says, I promise to pay you back the $100 you gave me at an interest of 50%, thus resulting in $150 return to
At
you.
any time. At any
And
time.
any time.
To
And there was
stimulate public confidence. I love how they
to
put that
stimulate public, say, yeah, you can come
in.
in, you can get your money at any time.
Any time, buddy. I'm good.
And so
Trust me,
basically what
bro.
in the first, yeah, the first couple weeks, he ended up raking in $9 million. And, basically he had issued about $14.5 million in notes.
Mhm.
And so this is why I think it's important just to understand how a mortgage works is anytime that you do a mortgage, you as the mortgager are saying, hey, I want that house that you have. And so I will make payments on that house. Here's a promissory note that you give to the mortgagee. You give
Mhm.
them the promissory note that says, I will pay back the principal balance. They give you the house. If you stop making payments, they take the house back. And so that promissory note that you issue, which is a promise to pay, is given to who's called the mortgagee. And what they can do with that promissory note is they can securitize it, they can invest it, they can make money on it, they can sell it, they can hypothecate it, they can do whatever they want. So what Ponzi was doing was basically getting people to loan him money, giving them a promissory note, and then created a market for securities where all these investors that had given him millions of dollars are now taking his promissory notes and using them as securities and making a bunch of money. And I think that's why a lot of them did not come, and immediately say, hey, we're here to make claim on those notes, even though before they're
Mhm.
matured, because they're making money. They're making 50% off of Ponzi, and then they're also investing his promissory notes and making a bunch of money as
A-
well.
And he has enough capital to cover one or two
Yeah,
creditors
and
that
that's the
come
thing.
in.
The
So,
only the only collateral that he had for these people was other people's money.
which we were talking about before we jumped on the call. It's almost like he read the Federal Reserve Act and took it as a blueprint for
Exactly,
what he
because
was
he's
doing.
there's at least in a mortgage, when they give you an asset, or they give you, like, if you're talking about a house, they give you a house, you give them a promissory note. And so in this case, they gave him money, he gave them a promissory note. So the money takes the place of the house in that scenario, where now the money is the collateral. And it's like if you are telling, if you got 100 investors and they're all going to give you $100, and you say, hey, all you 100 investors, I'm going to give you a rate of return of 50% and you can ask for it back at any time. It's like, okay, so if you have 100 investors now coming back to claim $150, yet each of them only gave him 100, where does the $50 come from to pay the interest?
Other people's money.
Other people's money. And so that's
Yeah.
why you're kind of hedging your bets on, I'm going to give these people so much confidence, so much public confidence that they don't come in and ask for their money back because I can't afford all of you coming back asking for your money at the same time. And
And
that's
that's
why,
exactly what happened to him, though.
yeah, and that's why I think he basically his motive was to create a market for securities where they're going to be making a lot of money off of these promissory notes, and they're not going to worry about calling in that loan.
Hmm.
And I think
Yes.
that's what they were doing.
Yeah,
Well,
yeah, definitely.
anyway,
And
there
it
was
go.
a newspaper article that ended up getting put out that Ponzi might be insolvent. And so you had some of these investors showing up first, rescinding their contracts, taking their money back. Couple months later, he is insolvent. Now he's going bankrupt, and you've got tons of creditors lining up wanting their money. And so what happened is the bankruptcy trustee for Ponzi said, hey, 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 we're in bankruptcy court here. Yet a couple months ago, we had people coming in getting their money back. They're basically eating out of the estate that we have to use in this bankruptcy case to pay off all these creditors. And the original creditors initially said, yeah, well, I mean, that was before the bankruptcy court case even started, and we're not taking it out of his estate. We're just taking our money back. And so a court of equity had to kibosh the whole thing and said, okay, those payments that were initially made to those people before the bankruptcy case started, that was an unlawful preference because what ended up happening is all of these creditors for Ponzi gave him a bunch of money and they put it into a general giant pool of money, a general fund, which means that if you deposit money into a general fund, equity says you do not have an equitable lien or an equitable interest because the money is not set apart and set separate. It's part of a general pool. Therefore, when it comes time to distribute the estate, regardless of who was first in time, everybody is going to get an equal share of the pie.
And yeah,
And that
and just to bolster that point right here, going on to point number three here in the case, just what you were talking about, where the funds of a bankrupt consisted entirely of money borrowed from many persons by fraud, a lender who rescinded and secured payments out of the same bank account, um, which is out of the same bank account in which his and others like loaned were deposited by the bankrupt, could not justify the repayment against the charge of illegal preferences upon the theory of a resulting trust or lien if the repayment was made after the account had been exhausted by payments to other lenders and after it had been replenished by bankrupt with other portions of the borrowed funds. As you were talking about there, the whole commingling aspect of this entire thing
Yes,
is
and
everybody
unrestricted
mixing the funds.
deposits.
Yes, unrestricted. Yeah, that's a yeah, unrestricted deposits. And what he means by that is so um if that where the fund is composed partly of defrauded claimants' money and partly of the wrongdoer, it will be presumed that in the fluctuations of fund, it was the wrongdoer's purpose to draw out the monies to which he was honestly entitled, and the claimant may assert an equitable lien over. But sh sorry, what were you what did you just say? The
No, I was talking about restricting their deposits because all of
restricting
these,
the yeah,
yeah, because all of these creditors, if they would have said, "Hey, I'm giving you this money, but I'm putting it on special deposit with you," they would have had a case because that right there, when you place something on special deposit, you create an equitable lien or an equitable interest on the property therefore deposited, and therefore later you can come back and demand that exact same money. And special deposit has to be kept separate from the general pool. So, like for
right,
example, if one guy came in and put, $1 million on special deposit and there's $9 million in this fund, the other creditors having deposited everything on general deposit, this creditor could come in, get his $1 million and walk away, and then everybody else would have the residue, the 8 million, equally distributed among them because they weren't smart enough to put it on special deposit, and they just get, they get the communism version of distribution.
right. And that's what I wanted to bring up. The point I wanted to bring up with that is because another factor that actually plays into this is um, the wrongdoer Ponzi. He actually started withdrawing the money before everybody could come run on the bank because he kind of saw the writing on the walls. And then obviously that puts a whole nother wrench in the game because these people didn't put their money on special deposit. Not only was it mixed with the other people's money, Ponzi came and took money. So who knows which money he took? And they're saying
Yeah.
here it's presumed that it was his money that he actually took, but nobody can tell because nobody put their money on special deposit.
Yeah, it's like, if like 40 people dump, like their water bottles into a pool, and then all these 40 people are like, "Wait, hey, this is a swimming pool. I want my water back." It's like,
Right. Yeah, sorry,
well,
bro.
it's literally we literally cannot tell whose is whose, and so we're just gonna have to divvy up everything equally.
Yeah, yeah, that's exactly right. And that's what it came down to here. And here on page 3 of the decision, it says the respondents would have the right to have their money back even if Ponzi had not deposited the identical money he received from them, but had substituted other monies belonging to himself. The right of the respondent to recover their property cannot be impaired by the trustee. Or wait, that's not what I was looking for there.
Well,
Um,
actually, that's, I mean, the right of the respondents to recover their property cannot be impaired by the trustee. So if
oh, right, because yeah, he was the trustee, wasn't he? The
Yeah, and that's where it says
Yeah,
underneath that Ponzi stood to them, and this is talking about um all the people who had given him money. Ponzi stood to them in
right,
relation to
right,
trustee
okay,
ex maleficio, which so I looked that up. I've got an old Latin dictionary. Ex means after, down, out of, or on account of, and
okay.
ma- malefi
Maleficio,
maleficio. I
Maleficio.
think that's, yeah,
Yep.
maleficio. It means to do evil, crime, injury, ill, wicked acts, wrongdoing, and
Oh, right,
sorcery.
right. Oh, wow,
It even listed
nice.
sorcery in there.
That's
So,
fucking nice. I like that.
so if you are a trustee ex maleficio, that means you are a trustee as a result of the crime that you have committed because you're defrauding these people. So
Mm.
you're basically a malevolent trustee. So you're defrauding these people and you're trying to make money, but equity's like, well, you know what? They were innocent. They weren't well informed. They didn't know what they were getting into, and you're trying to do things behind the scenes. Like you're doing ill, even evil, and wicked, and you are the trustee. Uh, so it's interesting
Hmm.
because below that too, it also says the respondents. So to back up a little bit, there were a couple creditors that went and got their money back. They rescinded it and were paid in full before the bankruptcy case took place. Because during
Hmm.
bankruptcy, a trustee takes over the estate, or basically, represents the estate, and then divvies it up for the creditors and also takes their share. The bankruptcy trustee was complaining because the people that had come in before to get their money back had diminished the amount that was available for the rest of the creditors.
Hmm.
And so, but those respondents never submitted themselves to the jurisdiction of the bankruptcy court, and the money which they received was not impressed with any lien or trust in favor of the trustees in bankruptcy. So what they're saying is like, at the time that we were repaid our money and we rescinded that contract, there was no lien on the money because this took place before bankruptcy. So they're telling the bankruptcy trustee, the respondents are telling the bankruptcy trustee, hey, buddy, you don't have a case because you didn't have an equitable lien on any of this.
Right,
But,
exactly.
but if the respondents were never creditors of Ponzi's estate in bankruptcy, but merely sestque trustant, their taking back of their monies out of Ponzi's hands in no manner diminished his estate.
Right, that's very interesting right there.
Yeah. And
Um,
that's the thing. They're saying if the respondents were not creditors, but they were in a trust relationship,
hmm.
then that money would not have diminished the estate. But again, they did not put it on special deposit. They did not
Right.
create an equitable interest. Therefore, there technically wasn't, they did not have an equitable claim on that money because they didn't put it on special deposit. So they dictated that those payments that were made to the original to the creditors that tried to get their money back were unlawful and illegal, and said, nope, all the money back into the general fund. We're going to split it up. All respondents and the bankruptcy trustee, everybody's getting everything equally.
Hmm. Yeah, I was just reading this too, and indeed it seems from all the evidence that until the election of Ponzi's customers to prove their claims in bankruptcy, there was no property in the estate upon which the bankruptcy court could lay hold. Until then, all property Ponzi had consisted of was trust money. So, so it was all trust money, but these people weren't the Sesticate trustants to it. He was the trustee. And
Exactly. Yeah.
because it was trust money, the bankruptcy court, because it's at law, had no, the bankruptcy court could, there was no estate that the bankruptcy court could lay hold on. I
Yeah.
thought that was super interesting. Which is proving the point, the point, bolstering the point of the split between law and equity right there.
And
Um,
so here's the thing is, so they're also talking about giving notice in here because it says certainly the bankrupt's estate was not diminished by the payments to the respondents. Because
hmm
again, during the bankruptcy case, now there is an estate, and there was money taken out before that, so it wasn't part of it. But there can be no preference without a depletion of the bankrupt's estate. The only evidence on which the petitioner can rely to establish that the respondents had reasonable cause to believe a preference would be affected is the newspaper report. So basically, what they're saying is that they're trying to establish the fact that there was no notice given to the public that Ponzi might have been insolvent, and therefore, that is the basis for our claims. However, it was a newspaper article and it was not published in the legal section. So they put a news article out saying that, Ponzi might be insolvent, and because it was in the newspaper, everybody knew about it.
hmm
And I think this is what the bankruptcy trustee was saying, is the respondents were like, well, hey, we got our money back and there was no equitable lien on that at all. And the trustee said, well, there was an article in the newspaper that said he might be insolvent, which basically has implications for all of the creditors. Therefore, now we've created a preference. Everybody knows this guy's insolvent. Immediately, preferences of creditors are created. And
Right.
therefore, you knew about the fact that other creditors had a rightful claim to that money. And so
hmm
they shot that down because he said that the respondents or any of them saw that report is purely conjectural.
Conjecture. Yep.
And so
Yep.
if they would have published it in the legal notices section saying, hey, Ponzi is insolvent, any creditors that have claims on this estate or this fund, please contact whoever it is. So that's
hmm
another thing too, is just because something is in the newspaper doesn't mean that it's going to be valid in a court of law as a matter of public record.
Right. Unless you do it in the correct way. That's got to
Yes,
be
unless
legal
it's done in the
notice
correct
and
way.
yeah, yeah, for sure. Um, yeah, that's an interesting little point there. Where as early as April, as Secretary testified, what was I looking for here? Um, oh, believe that they were insolvent. Okay, yeah, this is where you were. Was responsible a couple of, oh shoot, I can't remember. Oh, okay, yeah. So, they cannot come into the teeth of the Bankruptcy Act, and their preference and payment are avoided. But in other words, okay, the neighbor of the Hanover Bank was crowded with people trying to get their money, and for 8 days they struggled. Why? Because they feared that they would be left only with the claims against the insolvent debtor. In other words, they were seeking a preference by their diligence. Thus, they came into the teeth of the Bankruptcy Act, and their preference in payments are avoided. So they were trying to come in there under the Bankruptcy Act, and because they tried to do that, it actually, since they were trying to cause a preference, it actually voided their right to come in under law and adjudicate under the Bankruptcy Act because they were trying to come in to cause a preference to the creditors as a creditor. So they had one of two remedies. They could have followed the money wherever they would trace it and have asserted possession of it on the ground that there was a resulting trust in their favor, or they could have established a lien for what was due to them in any particular fund of which he had made in part of. So that's what we've been talking about. They could go in and trace all of the money and find exactly what dollars that they found or what dollars were there, or they could put a lien on it, an equitable lien on it. But because they didn't do that, because they then would have been endeavored to get their own money and not money in the estate of the bankrupt. But to succeed, they must trace their money, and therein they have failed.
Yep. And you can't trace it if it's not on special deposit and set aside. And you
Right.
can't keep track of it if it's in the general fund.
And so he's saying if they would have done that, then the Bankruptcy Act would have helped them. But
Yep.
they went in there thinking the Bankruptcy Act was going to help them and give them a preference, but them trying to use the Bankruptcy Act actually kicked them into a court of equity. And then so to get rid of the preference because their money was commingled. If their money had not been commingled, they could have used the Bankruptcy Act, which is
Yes.
that isn't that such a weird twisted way to think about it too.
Yeah, it really is because it's like it's a, that's how you get trapped. But
Right,
it's
you
interesting.
think it's an at-law remedy, this is what the law says. I have a claim, and they're like, yeah, but there's this whole
Yeah,
equity thing over here.
you didn't do any due diligence, so get in line, buddy.
Right, yeah, because you slumbered on your rights,
Yep.
you have none.
And
And
the thing is, what they're also pointing out too is some parties were trying to claim that Brown, in this instance, because the case is Cunningham v. Brown, and Brown
mhm,
is the one who was an infant, which just
yes,
means under 21 years of age,
under the age
had
of majority.
rescinded his contract and got his money back. And the thing is, it said the rescinding party has merely exercised the right of reclamation or reclaiming. Consequently, he is chargeable with no knowledge as to his relative rights as against persons who, as against him, have no rights at all. So what they're saying is, even though Brown initially he rescinded his contract, got his money back, he was 100% not aware that there might have been other preferences from other people because that's what they were trying to claim
Hmm.
is that he went in and got his money knowing that there were other claims on that fund, and that's why they
Hmm.
brought up the newspaper issue. But I wrote a note here. It said the rescinding parties had no notice of preference and were in fact reclaiming their property from an ex maleficio trustee. They were not inequitably drawing from the bankrupt's estate or general fund to the detriment of other creditors. So really, Brown had clean hands coming in because he didn't know that there may have been a preference created. He was
Hmm.
just trying to get his money back. Interestingly, a little bit of a side quest on that one is Brown was an infant, which means, again, under 21 years of age. And trying to find here. Yeah, so the main issue becomes a moot question as to the infant defendant, Brown. To repeat, a preference suit is not a bankruptcy proceeding. The statute merely lays down the terms on which the right of action is predicated, leaving the rest to the substantive law of the forum. By demanding and receiving his money back, Brown was only exercising his right of rescission as a minor under the age of 21, and therefore no transfer was affected.
Hmm. Hmm.
It is obvious that the dealings between Ponzi and Brown amounted to a contract and a contract not for necessaries. So what's interesting about the guardian ward relationship or somebody that's an infant is when you have a trustee, that trustee is tasked with giving you money for your necessaries. So for your well-being, for
Hmm.
your food, for your
They're your
rent, or
fiduciary.
yeah, basically a fiduciary relationship. And so what they're saying is that it is obvious that the dealings between Ponzi and Brown amounted to a contract, um, and a contract not for necessaries. And so he wasn't acting in his trustee duties to pay Brown for his necessaries as an infant. He was basically just giving his money back, which Brown was exercising under the right of rescission, which he had as a minor.
Hmm. And but the court did not uphold that.
Yeah.
But because point five here says a minor is not exempt from defeat of an unlawful preference. And that goes back to the whole commingling issue too. Had he not commingled his money, he would have gotten a preference, and not because he was an infant though.
Yeah.
So, um, and so we're running up on the end of the first hour here, so I just wanted to finish out this case real quick and um, yeah, to hit this last little point to really bring home what Mr. This is Taft, right? Was this Taft
Yeah.
that gave it? Yeah, Mr. William Howard Taft, Skull and Bones member here, give his little reasoning for what he why he decided the way he did. And this is on page 13, the end of the decision here. After August 2nd, the victims of Ponzi were not to be divided into two classes. Were not to be divided into two classes. Those who rescinded from fraud and those who were relying on his contract to pay them. They were all of one class, actuated by the same purpose to save themselves from the effect of Ponzi's insolvency. Whether they sought to rescind or sought to get their money as by terms of the contract, they were in their inability to identify their payments, creditors, and nothing more, because their monies were commingled. It is the case that the circumstances of which called strongly for the principles that that equality is equity, and this is the spirit of the bankruptcy law. So that's what he's saying. Equality is equity is the spirits of the bankruptcy law, even though
Which
they
is that's
weren't
a
at
heavy
law.
statement because bankruptcy is a huge thing, but they're saying the spirit and intent of bankruptcy is to do equality for all creditors who have a claim on that estate and that no
Hmm.
preference will be given.
Yep. Yep. Yep.
Unless unless there is a an active trust in place of something on special deposit or it actually is set apart, then it will not be considered as part of the bankrupt's estate for distribution. It will be
Right.
dealt with separately, and then all
Yeah.
other creditors who have something in a general fund will get an equal distribution.
Yeah. That's exactly right. So the point of this story is don't commingle, kids. Don't commingle. It's not worth it.
Nope.
Yeah. All right. So that brings us to the end of the first hour here. We got some juicy tidbits in on that one.
Yeah, and
That was some
honestly, there's
gravy
so
there.
much meat in that one that we probably could have gotten into, but it's just maybe that's something that we're gonna have to come back to because it's the Ponzi case.
Yeah, we might have to just come back to this case. I know because yeah, we really had to keep it on the rails here just to get through this one because there is just so much here. And I think this, and like I said, with Mr. William Howard Taft being the one who gave the opinion here, his father is the one who created Skull and Bones, just so everybody is aware. And then he was a member of Skull and Bones, and he's also the only person to be president of the United States and Chief Justice of the Supreme Court. So this dude is a mover and shaker. So, and I know me and Whitestone are of the same opinion here, where these opinions they're telling us stuff.
Yep.
Okay, this is for the people who actually want to stand on your rights, and they're telling you what to do here. They're telling you don't commingle your money.
Yep.
If you're gonna do investments and stuff, you better keep your money separate. Keep it in the private. And
Yep.
how you do that is by special deposit and keeping it away from everybody else's general funds.
Yep. Make it unique, set it aside. It's interesting, this case, it was 10 years after the Federal Reserve Act, and it was
Hmm.
10 years before 1933, which
Right,
is,
smack in the middle of
socio-political,
everything. Yep.
socioeconomic restructuring. So there's a lot in here that gives you an indication as to how the machinery of the world that we live in now is working and what the principles is based on. General fund, special deposit, waiver
Hmm.
and consent, guardian ward relationship, the marshaling of securities,
Yeah, it's
exercising
all
the right
here.
of redemption. I mean, it's all in there.
Yeah, it's all here. Yeah, so yeah, like I said, we might actually end up coming back to this case. But for today, that's all we got for the first hour. So in the second hour, I'll just give a little overview because in the second hour is only going to be available at the learningoutloudpodcast.system.io. Everybody can go there and get the show notes, get the transcripts, get everything for the show, everything that you see on screen right now. You'll be able to click through and look through yourself. So for the second hour of today's show, what we're going to do is we're going to go through this another equity maxim, which is first in time. That's on page 33 of Tuley's speech. And then from there, we're going to hit some more Pomeroy. And then we're going to hit another case, Martin v. National Surety Company, 300 US 588. And then from there, We're going to get into a little of the Geneva Bible that I found this morning. It's really juicy tidbits in there about decrees and building the second temple, and it's very interesting stuff. I hope to see everybody over at learningoutloudpodcast.system.io so you can check out everything with us. So, without further ado, that's all we got for the first hour. Never forget to seek truth and honor the Creator above all, and let that be the whole of the law.
That's the important thing here, is that everyone's word should be meant for a use.
And the words that I'm using today are meant to pull down idols within people's temples.
Meaning that I want to destroy
Falsities that they have idolized.
for their entire life.
And just pull those out and sweep them clean. And before that temple,
And get reinfested with a new lie. Give it true life.